All right, thanks for attending. My name is Ron Mondello. This is a presentation that is specifically designed for those municipalities that have opted in to cannabis, and again, specifically designed for governing bodies, mayors, council folks, many of which are my friends. And this is specifically on the personal use cannabis regulations or rules that were recently adopted. Again, my name is Ron Mondello. This is a website that I have, njmunicipalcannabis.com. There's a lot of information. I've got the statutes, I have the regulations up there, and some frequently asked questions. These are some of the organizations in New Jersey that I belong to, and I am the co-chair of the Municipal Cannabis Law Committee. And perhaps the most important qualification to give this presentation is the fact that I was a councilman in 2 towns, and I served on a planning board and zoning board for many, many years. All right, the purpose of this presentation, again, is to educate New Jersey elected officials on the new recreational or adult use or personal use regulations, rules. The goal is to assist municipalities that have permitted cannabis or will be permitting cannabis to retain that regulatory flexibility and the appropriate local authority. So let's start out with some of the municipal approvals for ATCs. Those are the medical cannabis facilities. And there are certainly many towns in New Jersey that are hosting these medical cannabis facilities. So I'm guessing that most of those medical cannabis facilities are going to be looking to expand into personal use. So your existing ATCs, they're not required to submit an application for personal use for a state license, but they do need written approval from the municipality. And it's my understanding the CRC, the Cannabis Review Commission, will be accepting municipal approvals from the ATCs beginning on the date of adoption of those rules that we're speaking about today, which was August 19, 2021. So you may find your current medical cannabis dispensaries seeking approval from your governing body. I'm not going to read this, but that's the section of the rules or regulation for the expanded alternative treatment centers. So what has changed with respect to these rules or regulations? Not much. In fact, in many instances, they are a mirror image of the statutes that were promulgated some time ago. So if your governing body was simply waiting to opt in because these rules and regulations were going to be an epiphany, that's not the case. But in any event, let's go through this quickly. So towns can enact all kinds of ordinances not in conflict. That hasn't changed. Towns can place numerical limits on the number of cannabis businesses. We know that. And towns can govern the location, especially the distances between schools, religious institutions, et cetera, et cetera. Towns can establish civil penalties for violating your ordinances. Towns can create and impose their own local licensing requirements. And towns are always free to prohibit any class of cannabis business. But again, and this was pretty clear in the statutes, a municipality cannot prohibit the delivery of cannabis or the transportation of cannabis through your municipality. By way of example, if you have opted out and you have no intentions of ever opting in, and there is a adjoining municipality, or for that matter, 3 municipalities away from yours, and they have a delivery service, that delivery service can deliver cannabis to your residence 24/7. Okay. All right, so again, this is in the statute. Municipality gets a copy of the cannabis application from the Cannabis Review Commission. The copy is sent to opt-in municipalities within 14 days. Here's a very important aspect of the rules It's also in the statute, but towns must within 28 days of receipt of the license application from the CRC, you have to indicate to the CRC, does this application comply with your zoning code? Does it comply with any other cannabis ordinances you have on the books? And if you don't do that within 28 days, the CRC may simply decide or deem that the application does comply with all of your local ordinances and regulations. Interesting aspect, the municipality may provide input to the CRC as to which applicant they prefer. How are you going to do that? I don't know. Will there be some type of first come, first serve basis? Will there be some type of scoring that the municipality does? The answer to this question remains to be seen. By way of example, you permit 5 cannabis establishments and you've got 37 applications. I don't know whether you ask the CRC to score those applications for you or your town, I should say, but that answer to that question remains to be seen. All right, let's move along. Municipal land use approvals. So how do you give an approval? You can provide an approval with a letter or an affidavit from the appropriate officials of the municipality stating that the location is appropriate, it conforms to your zoning, and variances, if any, have been granted. How do you provide proof of local support? Well, the intended location is appropriately located or otherwise suitable for activities related to the operation of the proposed cannabis business. So if you have a governing body, and quite frankly, I don't know of any municipality that doesn't, an adoption of a resolution would do it. However, if you are a unique municipality that has no governing body, then a written letter of support from the municipality's executive. Municipalities' local licensing or endorsement. Municipalities may create their own local licensing and endorsement. If a municipality does so, they shall notify the Cannabis Review Commission that it either approves or denies each application forwarded to it. That's somewhat repetition from the previous slide. I'm sure I don't have to mention this, but this is a very highly regulated field, and municipal government officials are going to need to be very careful. Do not solicit anything of value from the cannabis business. In fact, I don't know, should you be going out to lunch with that corporate cannabis business? I would think not. The cannabis business shall not offer anything of value. Is that a lunch? In exchange for zoning approval, proof of local support, or written approval for the cannabis business, or take any action that would violate our ethics rules. So I'm not sure. I just caution my friends and other elected officials to be careful. Not going to read this, but this is there is some repetition here with respect to the personal use cannabis rules, but there is some additional rules here of importance. The cannabis cultivator premises. Interesting. In no case shall a cannabis cultivator operate or be located on land that is valued, assessed, or taxed as an agricultural or horticultural use pursuant to the Farmland Assessment Act. So you're going to get property taxes on that cultivator's site. Again, in no case may a municipality restrict, this is repetitive, but restrict the transportation of cannabis items through or delivery of cannabis items within your municipality by adopting an ordinance. Any such restriction shall be deemed void. Another interesting rule, any state or local law enforcement or regulatory authority, that would be your zoning planning board, governing body, or agency, the Department of Health, may request that cannabis business personnel performing a transport or delivery present a cannabis business identification card or a copy of a transport order or delivery request. So if in fact you are a municipality that has opted out and there are deliveries being made in your municipality, the local law enforcement or these other entities we've just mentioned can ask for this cannabis business identification card. The rules shall be effective for a period not to exceed 1 year, and that would be August 19th, 2021. And let's move to the next slide. Oops, we didn't opt out. We didn't pass any ordinances. What now? The state will permit all cannabis establishments, with the exception of retail, to be located in your industrial zones. With respect to cannabis retail, they will be conditional uses in all of your commercial or your retail zones. And of course, they would be subject to meeting the conditions in those zones, subject to receiving a variance from one or more of those conditions. And after 5 years, a municipality can prohibit, but that would be prospective only. I hope that this has answered some of your questions. The rules have, in my opinion, for the most part, mirrored the statutes. So if you are a municipality that was waiting for the rules and regulations to opt in, now's the time. Thanks for attending.